If it is property, like how does one sell it? How does one monetize their own data? It's still hard to think about how that scales in these scenarios and what kind of uptake you would get. Like how many people are actually going to bother to opt into that, right?
Hello everyone, I am Sergio Maldonado and this is Masters of Privacy, a set of interviews covering the intersection of marketing, data, privacy and technology with a clear goal in mind, which is redefining the relationship between people, brands and media around transparency and control. Which is to say, we're aiming for real customer centricity, or if you will, human centricity. We regularly talk to DPOs, CMOs, CDOs, and whoever else we find interesting and able to share valuable insights. So we hope you like it. Please do reach out if you have any ideas on future topics or speakers. Okay, there is clearly a growing trend in private enforcement of privacy and privacy-related laws, old and new, across the US in the digital marketing arena, specifically against embedded third-party pixels, mobile SDKs or software development kits, and similar data collection or audience targeting technologies. Others would simply describe this as a wave of aggressive and opportunistic litigators seeking their own profit rather than coming to the rescue of vulnerable consumers and their fundamental rights. Either way, the laws are there for a reason, and as Daniel Rosenzweig, our guest last week, pointed out, the recent wave of lawsuits is even prompting some data controllers to just dump their website conversion pixels and trackers served by Google, Meta, Snapchat, or TikTok. In case there was not enough of a minefield, and Daniel mentioned specifically CIPA, or the California Invasion of Privacy Act, and I believe we mentioned the Video Privacy Protection Act, the state of Washington enacted in 2023 the law that was, according to some, the most worrying of all, My Health, My Data, which entered into force last year. We had already covered the basics of this law in another episode, specifically in our summary of the PSR LA event in November, in which Mike Hintze of Hintze Law had spoken together with Justine Young-Gottschall about it. But a few months have passed and there have been new developments. So we asked Mike Hintze to help us put together an update. As it happens, some of these developments took place before our interview, and one of them happened right after, with the first ever class action being filed under My Health, My Data, along with a whole bunch of other laws on February 10th, so 2 weeks ago, for the use of SDKs in popular mobile apps. So, to make the most of this episode, we're splitting it in two parts. The first will be much longer, but first we'll hear Mike Hintze talk about My Health, My Data, the case against Costco under the Washington Consumer Protection Act that sort of paves the ground for My Health, My Data lawsuits, since enforcement of this act, of My Health, My Data, happens through the CPA, through the Consumer Protection Act. And also about similar state laws popping up across the US to address this wider notion of health-related data and apply it to entities not covered by HIPAA compliance, right? Like regular business websites or mobile apps. Also, we will ask him about an unrelated topic, which is the new restrictions on data transfers of personal data about US citizens to third countries, which apply, so people will have to comply with, as of April this year, so it's quite urgent. Okay, after all this, we will do a basic breakdown of that first class action in which the defendants are Amazon Ads and Amazon itself. So, let's go for the interview first, and let me introduce our guest, Mike Hintze. He is a well-known leader in the field with more than 20 years of experience in privacy and data protection. He has been a partner at Hintze Law since 2016, and prior to that was Chief Privacy Counsel at Microsoft for 18 years. He also teaches privacy law at the University of Washington School of Law and has served on multiple advisory boards. he has testified before Congress or, for example, European regulators. So let's go for it. Mike, thanks for joining me.
Oh, my pleasure.
So again, I really enjoyed your panel back in LA on My Health, My Data, and it's been a few months. So it'd be good to know whether there's any updates worth discussing or anything that you think is taking shape in terms of enforcement or whatever you think is worth, mentioning.
Yeah, happy to chat about that. And thanks for the opportunity to chat with you and your listeners. Um, as you recall, My Health, My Data is a very sweeping, broad healthcare privacy law that was passed in Washington State last year. It came into effect last year, and it covers a very wide range of health data, anything from what you might consider traditional diagnoses or information about conditions to really anything that touches on nutrition or wellness or fitness. The definitions are potentially very, very broad. And that's raised concerns among a number of companies because it could potentially affect a lot of companies, both inside and outside Washington State, that don't think of themselves as in the health space, but they may be collecting information about purchases, about uses of products, about browsing history, and things like that, that could certainly trigger this law. And in addition to being enforced by the Attorney General, it has a private right of action. And so there was a lot of concern that this would lead to class action litigation, a very aggressive plaintiff's bar, bringing cases against companies. What's probably most interesting, and I'm happy to talk more about the details of that law, its coverage, what the substantive obligations are. But what's interesting over the last several months since it finally came into effect is that we haven't seen enforcement. We haven't seen enforcement from the Attorney General's office, which, given having gone through an election season recently, that might have been, kind of a nice thing for the Attorney General to show in election season, but we didn't see that. And we haven't seen it from the plaintiff's bar either, which has really been a bit of a surprise because, you often see the plaintiff's bar being very creative in taking laws and interpreting them aggressively and creatively, and then sending out demand letters to companies, hoping to get quick settlements or, bringing cases that might bring larger rewards at trial. And it's been a little bit of a head scratcher as to why we haven't seen that. And I think one of the reasons is that for private plaintiffs, they need to show injury in order to bring a claim. And the claims under My Health, My Data Act are brought via the Washington Consumer Protection Act. And the showing of injury under the Washington Consumer Protection Act is actually phrased as injury to business or property. And the courts have interpreted that to mean things like, emotional distress or things like that aren't going to be good enough. That has to be something, that's tied to business or tied to property. So reputational damage might be enough because that could affect your business opportunities, or something that could have an economic effect on you. And that brings us to one of the updates I wanted to raise. There was a case just a couple of months ago here in Washington State, not under My Health, My Data, but under the Washington Consumer Protection Act.
Yep.
And one of the issues that was brought, the name of the case is Castillo versus Costco. It was brought against the Costco retailer. And it involved pixels, a meta pixel in particular, on some of their website pages that had to do with pharmaceuticals or health products. And one of the claims was under the Washington Consumer Protection Act. And in the motion for summary judgment by Costco, they said, well, there's no injury here. You can't show any injury to business or property. And the judge, surprisingly, said, well, yes, there's lots of studies that says that, browsing data is very valuable for advertisers. And so there's an economic value there. And I think the language of the court was something to the effect of, now having made this data widely available, Costco has effectively diminished the economic value of that data, which is, really interesting for a lot of reasons. Like, one, it wasn't, you could quibble with whether it's, widely or effectively publicly available that would diminish its value. And two, you could quibble with the fact that yes, there may be studies that show economic value of this data to advertisers, but that's not an economic value that individuals typically have access to. I can't just like say, hey, I've got some browsing data of mine, I'd like to sell it on eBay. Like, that's just not a thing, right? And so how does that diminish and is this property of the individual? The court never addressed that. So it may get overturned on appeal. But it is interesting in that it potentially opens up a new avenue for plaintiffs' lawyers to say, oh, if that's all I need to do to show injury under the Washington Consumer Protection Act, I can certainly show injury under My Health, My Data for a variety of scenarios. So it'll be interesting to see whether that provides a bit of a roadmap and maybe opens up the doors to the plaintiffs' bar paying more attention to My Health, My Data. And there's all those, theoretical and economic discussions you can have about whether or not it makes sense to assign a property value to personal data. But there's also just the practical mechanics of it. Like, if it is property, like how does one sell it? How does one monetize their own data? You'd have to have a very complex system of tracking and micropayments and all of that. And that infrastructure just doesn't exist today. So there's just, even if you theoretically think it makes sense to assign a property value to personal data, I personally don't think it does, but there's just no practical way to implement that in a way that individuals could extract that value.
So in the case of the grocery stores, for example, Costco is a very good example, because I know the large chains are very worried. So I understand there's two scenarios here. One is that they are addressing the local market. So they're addressing residents of Washington state. And that's very clear. Another one, which is very concerning, and you discussed that, is that they are relying on some data processors, because it's about you being the controller from my sort of GDPR perspective of the data, and then you're relying on the data processor in the state, and by relying on systems that are in the state, that you could be liable. Is that it, as a territorial scope, that by relying on AWS?
Yeah, that's true. The territorial scope is defined as personal data related to any Washington state resident, personal data related to a person who happens to be located in Washington state, or personal data that is processed in Washington state. And, as you know, the definition of process, it's a GDPR-like definition. It's very, very broad. So yes, if you have no connection to Washington state as a retailer, for example, and your customer has no connection to Washington state, but that data is being processed in an AWS data center or in a Microsoft Azure data center located in Washington state, that's potentially covered under the strict reading of the definitions. So the territorial scope is potentially incredibly broad, particularly given that two of the largest cloud providers on the planet are located in Washington state, headquartered in Washington state, with large data center footprints in Washington state.
So then there could be a grocery chain, one of the giants in the US, that is surely relying on some data center in the Washington state for maybe certain websites. And so the fact that I am browsing their website and looking for some articles that could fall within these categories, because they could define my health or my interest or some pathology.
Sure.
That will really be subject to this.
Correct.
And so in that case, I've got two avenues. One of them is consent. Another one is necessity, if I understand.
Yeah, well, there's actually three avenues, depending on what you're doing with the data. So if necessity is, it's necessary to provide the consumer requested service. So if all you're doing is, buying heart healthy groceries at a grocery store and the grocery store is using that to facilitate your transaction, no issue there, really. If they want to do something else with it, and there's lots of questions about how broad necessity will be interpreted. Is it sort of strictly necessary or reasonably necessary? There's a lot of room between those two, right? But if it's not necessary, however that's ultimately interpreted, then you would need to get consent. And it's GDPR level consent, specific, unambiguous, informed, all of that stuff. But if the thing you're doing with the data is something that would constitute a, quote, sale of the data, and sale is defined broadly, similar to how it is under the California law and some of the other US state laws that have emerged, which generally would cover third-party targeted advertising scenarios. So if you're, have a pixel on the grocery store website and that's being shared into the online advertising ecosystem, that would potentially be a sale, and that would require something more than consent. That would require what they call authorization. And authorization is a written, signed document that specifies the specific personal information that's being sold, the specific buyer of that personal information or buyers, and then lots of sort of boilerplate disclosures about consumers' rights. That authorization only lasts for a year, is revocable at any time. It's a very onerous process to go through, and obviously not scalable in terms of the typical online advertising ecosystem. So that's another area of concern, that in effect this authorization requirement, because of its lack of scalability and the high bar it sets, would effectively be a ban on using some of this data for things like online targeted advertising. And again, listeners may say, oh, well, that's great. If you're talking about sensitive health data, maybe that shouldn't be used for targeted advertising. But the definitions are so much broader than that. It's, an interest in fitness, an interest in, like I said before, heart-healthy groceries, other wellness products, over-the-counter medications, it's all potentially swept in here. And then, it's just the implications are very, very broad and very, very concerning for a lot of companies.
So if, for example, I'm using my Oura ring, right? So to track sleep or any of these rings, that data, if that data is on the one hand being used to serve the purpose, so I need that data so I can track my sleep, that would be part of that need. But if the Oura ring wants to use that data to improve the product, to do something that is not necessary for it to work, for me to see these dashboards and change my patterns, then that would require consent.
I think that's right. Sort of R&D is kind of the typical example of something that might not be necessary, but wouldn't be a sale of data in most cases, internal R&D. Now, I think there is a argument to be made. In some cases, you might be able to make the case that product improvement is necessary if you have, from the very start, positioned and marketed this product as something that continually improves, right? The classic example is an email spam engine, right? Spam engines don't work if they don't continually improve and keep up, right? That's part of the core functionality that you have sold to the consumer and what they have effectively requested. So I think in scenarios where you could make a credible claim that improvement is just part of the core operation of this service that consumers expect because you've marketed it that way, and given the nature and the context of the service, they expect that. I think you could make a necessity argument there, but that's going to be very case by case, in fact, dependent.
So, for example, I'm selling gluten-free pizzas on Kroger, or they may be selling them to me. And the fact that I buy it, eventually that's being dumped by grocery chains, by retailers, by direct-to-consumer websites, through conversion APIs, for example, to either directly the platform where they buy the ad space, for example, Meta, or a data clean room like Amazon's. And in both cases, the recipients are clearly identified. So I would need to have a contract in place. And it does not sound as complicated as a sale of personal data in the California sense.
Yeah, I think that's right. I think that scenario you raised would be a, you know, pretty there's a strong argument that it's covered by this law. The purchase of gluten-free pizzas could be indicative of celiac disease or other similar conditions. If you are using one of these conversion APIs or data clean rooms where you do know who the recipients of the data would be, it may make that authorization at least plausible, right? Because it's not kind of this open advertising ecosystem. So it's conceivable there are scenarios where even in the advertising space where companies may choose to go after this kind of authorization, but it's still quite burdensome. It's a very, a user has to, sign it either physically or electronically. It's a very bespoke scenario saying, hey, this is the data of you that we're selling to this party or these named parties. And it's still hard to think about how that scales in these scenarios and what kind of uptake you would get. Like how many people are actually going to bother to opt into that, right?
Exactly.
And so is it even worth the trouble?
Exactly. That's a good point. Yes, yes, yes. So before we change tack, anything else? Should we just look at the Washington State, and is this just something that happened because you got inspired in that corner of the world, even though it's very important from this point of view, or is there anyone else doing the same thing?
Yeah, so last year, both Nevada and Connecticut passed laws that were somewhat modeled on the Washington law. They don't have a private right of action. They're narrower in scope. The Connecticut bill was an amendment to their existing comprehensive privacy law that just brought in some additional requirements around health data. So those haven't been as concerning as the Washington law that has the private right of action and the much broader scope and definitions. But very recently, New York State just passed, their legislature, both houses of their legislature passed a law that is modeled on the Washington law, but is even broader and stricter. It's currently on the governor's desk. A veto is not expected, so she will likely either sign it. She also has the ability to make some amendments at the governor's level before signing it, so we'll see if that happens. But this law is similar to Washington. The definitions are different, but equally broad in terms of the data that could be potentially covered. And instead of having sort of that three tier we talked about of necessity, consent, and authorization, it has necessity, and then it goes straight to authorization. So in that sense, it's stricter than the Washington bill. Anything that is not necessary to provide the service or subject to one of the exceptions in the statute would require that authorization, which is very similar to the authorization under the Washington law. So, that's another development. There's not a private right of action under that statute. It would be enforced by the Attorney General of New York State, but it is potentially as broad and more onerous than the Washington bill or law.
Thank you. Last question, changing tack entirely, but we've always seen the U.S. as the bad recipient. Let me say that, right, of European data, right?
So you Europeans.
Exactly, yeah, the country that should not receive any data about Europeans. But now it's the U.S. is imposing restrictions on people sending data over, out of the U.S. And I understand it only concerns sensitive data, but I'm not sure. You have a blog post on your colleagues have published on your blog, comprehensive article. Any thoughts on that, on these cross-border data flows from the U.S.?
Yeah, it's really a big deal. It does restrict data flows Primarily, most of the provisions are focused on what are called countries of concern, and that is China, Cuba, Iran, North Korea, Russia, and Venezuela. Most of the attention's been on China because they're the largest economic actor among those countries. And many US companies and non-US companies have a lot of ties to China in terms of customers or partners or investments or et cetera. So it's a very, very complex set of regulations. It's focused on bulk sensitive data of US persons or data related to US government activities. But let's focus on the bulk sensitive data of US persons definition. The definition of sensitive data is incredibly broad. It's not just sensitive data in terms of, special categories under the GDPR or even how sensitive data has been defined under some of the US state laws. It includes things like common benign identifiers if they're combined with other personal information. And the definition of bulk data varies depending on which subcategory of sensitive data it is. So this one with the common identifiers, which could be an IP address combined with an email address, like that's literally sensitive data under this definition. But the bulk definition there would be 100,000 US persons, as opposed to genomic data, where the bulk definition is 100 US persons. So it's a very complicated definition with different numerical thresholds depending on what type of, quote, sensitive data it is. And it prohibits certain transactions. It prohibits data broker transactions, so selling data to a country of concern or a covered person, which would be a resident of a country of concern or somebody working for a company based in one of those countries of concern, or where there's 50% more of investment in a company from one of the countries of concern. So there's also a very complex set of definitions about who's covered and who's sort of a covered person or a covered entity tied to a country of concern. But then there's a number of restricted transactions too. And that includes data brokerage transactions of bulk sensitive data to any non-US person. So it's not just limited to those countries of concern. So if a US company is selling data to any entity that's not a US person, there would be certain restrictions on that, including contractual restrictions that would have to flow through saying, hey, you as the buyer, you as the non-US buyer, cannot resell this data to any country of concern or person tied to a country of concern. And there's certain record keeping and reporting obligations that go along with that transaction as well. And then there's, I could go on and on and on. There's various different iterations and types of transactions. It can affect vendor transactions. It can affect employment or investment transactions in certain cases. It can affect even using pixels. We were talking about pixels earlier on websites. If that company behind the pixel is based in or controlled by one of these countries of concern, right? And so, it's potentially very sweeping and very complex. And most of it comes into effect in April of this year. So there's not a lot of, and we're talking about things that would require new contractual terms, et cetera, new compliance programs, new due diligence to figure out whether or not the entities you're dealing with are potentially covered by this. So there's a lot there. Now, we have a new administration here in the United States and throwing a lot of things into chaos and reversing a lot of things that the prior administration did. So we'll see if this gets delayed or changed in any way. But this is not an administration that's particularly friendly to the named countries here. So, we'll see how that all plays out. But it's causing a lot of concern right now.
I'm not sure how they're going to avoid circumvention through third countries.
Yeah, and that's always a problem with restrictions on cross-border data flows. There are some parts of the rule that require effectively due diligence. It's unclear about what level of policing that will require by the individual companies that may make that big data available to non-US persons. Clearly, there's going to be some contractual restrictions in there, and that'll probably be the first step. But there's also provisions in there about reporting to the Department of Justice in the US if you have knowledge that circumvention has occurred. So, it'll be a combination of things, but obviously, as the markets for data and the way data flows around the world, it's very leaky, and hard to really fully grasp or control what happens to data. So, I think companies will probably take a phased approach, focus on contracts first, focus on their internal compliance and due diligence first, and then kind of see how this thing evolves.
Thank you, Mike. Very interesting. Thank you very much again.
Yeah, of course.
Okay, that was the interview. Now let's go for the case. This case is about the SDKs, again, that are embedded in a vast majority of ad-supported mobile apps out there. Specifically, the named plaintiff was using the Weather app or the Weather Channel, an offer app. But there's many more, and many of them are extremely popular tools or games like Speed Test, Truecaller, or Paper.io. And it's not just filed under My Health, My Data, but under, as I said, a whole bunch of laws, right? Like the Federal Wiretap Act, the Electronic Communications Privacy Act, the Consumer Fraud and Abuse Act, the Stored Communications Act, and even violations of privacy under common law. But the action is not filed against more traditional data controllers like those publishers of the apps or advertisers, but instead against the supplier of the SDK. A little bit like it happened with the Segment case, right? The customer data platform, where the defendant was the supplier, again, of the pixel, so Twilio, who own Segment. But in that case, we were talking about MarTech. And now we're looking at Amazon Ads, which is ad tech. So instead of suing a data processor, and I think the distinction is important from a legal point of view, we're dealing with an active market participant that can also behave as an independent data controller. Anyhow, picking Amazon Ads and Amazon itself for these particular grounds sounds like a very safe bet in this first case in terms of jurisdiction or venue. Here's an introductory paragraph in the claim.
Hundreds of millions of Americans carry their cell phones with them wherever they go. Having harvested the information about private moments and movements that these cell phones contain, Amazon has monetized this information in a triumph of profit over privacy.
After that, quite predictably, the claim argues that there are no privacy disclosures, there's no opportunity to prevent Amazon from accessing, for example, the user's location data once such location has been granted to an app like the Weather app so that it can do its job. And also nothing is mentioned about transfers of such data to third parties or data brokers. Then it goes on to provide specific grounds under My Health, My Data.
Amazon collected plaintiffs' consumer health data, including biometric data and precise location information that could reasonably indicate a consumer's attempt to acquire or receive health services or supplies. Prior to harvesting and sharing plaintiffs' personal data, Amazon never obtained consent. Nor did Amazon clearly and conspicuously disclose the categories of consumer health data collected or shared, the purpose of the collection or sharing of consumer health data, the categories of entities with whom the consumer health data is shared, and how the consumer can withdraw consent from future collection.
And the interesting part is the one that connects with what Mike Hintze was referring to in the Costco case in order to prove actual injury to business or property, which is the sort of harm, again, required by the state's Consumer Protection Act. And I will simply quote this paragraph.
Plaintiff has suffered injuries, in fact, and lost money or property due to Amazon's business acts and practices. Plaintiff's personal data has tangible value. Their personal content is in the possession of third parties who have used and will use it for their own advantage, including financial gains, or was and is being sold for value, making it clear that the person content has tangible value.
Anyway, this block is very interesting because courts are not immune to the oversimplification happening out there concerning this idea that you can make money out of selling your personal data, or that a fundamental right should become a commodity or a luxury for those that can afford to not put a price tag on it. So I want to finish with a couple of thoughts, which are my own opinion, to connect this with other interviews we've had in the past regarding the idea of ownership over personal data. The first thing I'll say is that most of personal data signals that we scatter and collect out there in the digital space are not pre-existing and immutable, but instead are born with every digital interaction and even shaped by the digital asset that we happen to come into contact with at any given moment, right? Think of things that do not exist yet. A smart coffee cup that now measures how you hold it, a smart surfboard that measures how you ride, or a smart tennis racket or a golf club. Basically, some properties out there that, again, didn't exist before. And the nature of the digital asset or the object defines the spark, so to speak, that will be produced once an individual incorporates that signal to her profile. And it doesn't have to result in the inference of a particular personality trait in a universal predefined taxonomy or under pre-established archetypes, right? There are exceptions like pieces of information that become windows to our attention or bridges to our time, like an email address or a phone number. So those carry an invasion of our time with them, right? And there are those that are so close to our identity in a given context, like a driver's license, right, or a date of birth, or truly immutable data points like a DNA or biological markers, that they pose a high risk of identity theft, and worse, like cloning, for example, one day. So putting them in the stream of commerce would be the last thing that you want to do, as there would be no effective way to exercise your rights. And then there is the problem of value that Mike was referring to as well, right? Certain signals will in fact gain value, not lose it, as the judge was saying, right, in the Costco case. They will gain value from being shared and combined, right? So this is what some people call the anti-rival nature of data. And I was discussing that in our interview with Gam Diaz, I believe, a couple of years ago. Now, I really think that a very different story is at play when we get paid to answer surveys or expose preferences in a way that individuals remain, or that these items, these preferences remain within our sphere of control under the concept of real zero-party data and not just declared first-party data. But that is another story altogether for another day. So I am glad that there is still another paragraph in the claim pointing at a very specific and real harm, which is the good old identity theft, although we will have to see whether it meets the definition of actual injury to business or property. And here it goes.
The personal data shared with third parties allows that data to be aggregated with other data to identify and target plaintiff. Accordingly, plaintiff is at an increased risk of identity theft due to Amazon's practices concerning the harvesting of such data and sharing of data with third parties.
This is it for today. Thanks for listening. Follow us on Blue Sky or LinkedIn, and please feel free to give us 5 stars in your favorite podcast player if you think we deserve them, as that will help us grow and bring more and more interesting guests. Thank you for listening.